Thanks very much. My questions are for Krista Carr from Inclusion Canada. Ms. Carr, I would like to give you a little bit more time to explain your particular position on this. First of all, why are you recommending an amendment to the proposed legislation that some may say goes against the decision of the Quebec Superior Court judge in the Truchon decision?
Well, Inclusion Canada takes the position that first of all, it's extraordinarily rare to see changes in the criminal code made in response to one trial decision in one province. One trial court in Quebec or any other province for that matter cannot and should not determine the rights of all Canadians. That's inconsistent with our federal system. And as you know, we pleaded with the federal government, the disability community nationally, to appeal the Truchon Gladue decision. And by refusing to appeal, the Department of Justice has put us in a bit of a bind. And there are some responses to that. You know, perhaps the simplest is go back to the Quebec court and ask for more time. We're talking about the life and death situation of Canadians with disabilities. Surely we shouldn't be doing this in a hurry. Another alternative would be to let the suspension of invalidity lapse in Quebec. That might sound like a drastic response, but it's not uncommon to have provisions in the criminal code struck down in one province and not others. That happens in our court systems all the time. And the federal government doesn't amend the criminal code until the Supreme Court of decision. The Supreme Court of Canada binds all courts in the country for that. And this would allow us another case that we could move through the legal system and bring it properly through the Supreme Court. And thirdly, another option would be go directly to the Supreme Court now with a reference question on this matter and get the fulsome hearing that Canadians were denied with the Truchon decision.
Okay, thank you. And I know you were one of 70 groups that wrote to the Justice Minister to try to encourage him to seek that appeal. And I'm not sure if you had a chance to watch my questioning of Minister Lametti this morning, but I was telling him how surprising I found that decision to be, that he did not appeal. My second question to you is, Ms. Carr, can you elaborate on why you believe it's discriminatory for people with disabling medical conditions to be able to access assisted dying when they are not at the end of their lives?
Because the singling out of one particular group of people based on their personal characteristics that happen to be a protected ground under the Charter of Rights and Freedoms, and to use that reason as a grounds to justify the termination of their lives, the lives of the people who have those characteristics, is just wrong. And we wouldn't consider doing this. We wouldn't even consider doing it for any other charter protected, we would never consider doing this for any other group of people. Indigenous, racialized, LGBTQ. We know these groups suffer disproportionately, not because of who they are, but because of what society and systems and people and discrimination does to their living situations. But in those cases, for those groups of individuals, we do everything we can to save their lives, as we should do. But why not for people with a disability? Are their lives not worth as much?
Right. Thank you. And that's because you're saying that the end of life criteria is really the only criteria that you're saying is not applicable to disabled people. Once you take that away, everything else applies to people who are disabled potentially, correct?
That's right.
Thank you.